Hey Ostika, welcome back. And it feels like the courts were busy as ever, even with the Dashera break looming. So, what are we starting with today?
Hi Devajit. Let's kick off with a high-profile case coming up in the Supreme Court right after the break. It involves the detention of Ladakhi activist Sonam Wangchuk under the National Security Act.
Yes, Ladakh. Ladakh has been in news for massive protests demanding statehood, sixth schedule inclusion, and job reservations. People were told revoking Article 370 would bring autonomy and development, but many feel those promises were broken 6 years later.
Exactly. The flashpoint was reportedly on 24th September. Thousands were gathered in Leh, according to reports, to support Wangchuk and others on a hunger strike, but things apparently turned violent. There was arson, stone pelting, and clashes that tragically left 4 people dead and nearly 60 injured. The Ministry of Home Affairs was quick to point the finger at Wangchuk, calling his speeches provocative, and he was detained under the NSA 2 days later.
And his wife, Dr. Gitanjali Angmo, has now moved the Supreme Court. She's filed a habeas corpus petition, right? So why this particular route?
So that's the classic constitutional remedy for challenging illegal detention. Habeas corpus literally means produce the body. It lets someone ask the court to make the authorities bring the detained person before it and explain why they're being held. His family has had no contact with him since the arrest. So they're asking the court for urgent clarity on his health, welfare, and the legality of the detention.
Right, that makes perfect sense. The court is on break, so when will the matter be next heard?
The Supreme Court reopens on 6 October, so we can expect it to be mentioned for an urgent hearing early next week.
And just to quickly touch on the NSA, the National Security Act, how does the law even work here?
The NSA is a preventive detention law. It's unique because it lets the government detain someone not for what they have done, but for what they might do if they're seen as a threat to public order or national security. A person can be held for up to 3 months without trial and sometimes up to a year.
That sounds pretty harsh in terms of rights.
It is. A major criticism is that detainees don't have the right to a lawyer before the advisory board that reviews the detention, and the government can withhold facts citing public interest. This law, of course, is meant for rare, exceptional circumstances, and the courts have repeatedly cautioned against using it to stifle protest or dissent. Wangchuk's case really puts the spotlight back on how these preventive detention laws are used in the country.
Moving over to Assam, the tragic death of singer Zubeen Garg in Singapore has also reached the Supreme Court. So what's the organizer here asking for?
That's Shyam Kanu Mahanta. He was the organizer of the festival Garg was supposed to perform at, and he's gone to the top court asking for protection and a probe transfer. What was initially thought to be an accidental drowning has taken a serious turn according to reports, with allegations of poisoning now coming up.
And Mahanta's name has come up, along with singer's longtime manager, Siddharth Sharma, right?
That's correct. Sharma has been arrested on charges including criminal conspiracy, murder, and culpable homicide, and Mahanta is also now under arrest. Mahanta, however, claims he's caught in a witch hunt, facing over 50 FIRs, a media trial, and public vilification.
So what's he seeking in this petition here?
He wants the Supreme Court to shift the investigation from the Assam Police SIT to an independent agency like the CBI or NIA under a retired judge. Plus, he's asking for a stop to coercive action against him and his family, unfreezing his accounts and de-sealing their home. Legally, he points out that Singapore authorities found no foul play in the drowning, and he wasn't even at the spot that day.
That actually raises a big question about whether the Supreme Court will step in and grant this protection.
That's correct.
Let's move on to a sensitive case about a student's well-being here. The Supreme Court has asked IIT Kharagpur and IIT Delhi to respond to a plea from a student seeking a transfer for mental health care.
This student has been diagnosed with borderline personality disorder and depression. His argument is that staying at IIT Kharagpur is making his condition worse, and moving to IIT Delhi would allow him to access treatment at AIIMS and be near family.
And he's leaning on the Supreme Court's past Sukhdev Saha judgment, right?
That's right. That was the case where the court laid down nationwide guidelines for students' mental health. In Sukhdev Saha, the court said mental well-being is inseparable from the right to life and dignity under Article 21. It really criticized the toxic rank and result culture in our education system.
The court even issued 15 guidelines for things like suicide prevention and mandatory counsel.
Exactly. So in this transfer case, the petition argues that if mental health is constitutionally protected, denying the petitioner the move he needs for treatment could actually be a violation of his rights. It's a key test of how those powerful past rulings are actually implemented.
We also saw the Madhya Pradesh government defending its move to raise the OBC reservation from 14% to 27%. What's their core argument here?
The Madhya Pradesh government has filed an affidavit arguing that scheduled caste, scheduled tribe and OBC groups together make up 87% of the state's population. They say that keeping the OBC quota at only 14% is wholly disproportionate to their actual numbers and underrepresentation in public services in the state.
But doesn't the famous Indira Sawhney judgment cap reservation at 50%?
That's the legal note. The Indira Sawhney judgment set the 50% cap, but it also did carve out an exception for extraordinary circumstances. So Madhya Pradesh is arguing that the state's demographics and underrepresentation are in fact extraordinary circumstance. However, the High Court had already stayed anything above 14%, so the implementation is paused until the Supreme Court gives its final word.
Another very serious story this week was the tragic stampede at a political rally in Karur, Tamil Nadu, organized by actor Vijay's party, the Tamilaga Vetri Kadagam. At least 39 people lost their lives there.
The Madras High Court has been extremely active on this. They first entertained a suo motu plea and even noted that the party itself alleged a conspiracy. Petitions were filed seeking nothing less than the de-recognition of the party.
De-recognition on what grounds?
The argument is that by letting vulnerable people like children and the elderly into unsafe conditions, the organizers violated the fundamental rights under Article 21, along with constitutional duties concerning children. The court eventually rejected demands for a CBI probe, saying it was too early in this stage of investigation.
So what did the court do instead here?
It constituted a special investigation team or SIT headed by an IG rank officer. Crucially, it also told the state to frame standard operating procedures or SOPs for political rallies. Until those SOPs are ready, no party can hold meetings outside designated venues.
That's a huge move for political safety, public accountability, and what about criminal liability here?
Several TVK functionaries, including the general and joint secretaries, have been booked under serious charges like culpable homicide not amounting to murder. Their anticipatory bail pleas have been dismissed, and the High Court really criticized the party's attitude, pointing out that the leaders abandoned the site after the tragedy. It's a devastating human tragedy that has turned into a major legal storm about political accountability now.
Moving on, the Kerala High Court is making a very bold technological move, I've heard.
They are. Starting November 1st, every trial court in Kerala has to record witness depositions using Adalat AI, a speech-to-text tool. It follows a successful pilot that showed hearings move faster and delays dropped.
That's actually a massive step towards modernization. Can you tell us how does that work?
The witness statement is recorded, endorsed, signed and then uploaded directly into the digital court management system for lawyers and litigants to access. They have fail-safes. If the AI fails, they can switch to other approved tools, but they have to ensure confidentiality and data security. It's a huge push to use AI in the core of trial work, not just administration, and Kerala is definitely leading the way in testing those boundaries.
And next we take a look at an unusual maintenance case from Allahabad High Court involving a minor husband.
Yeah. A boy who was 13 when he got married and a father by 15 was ordered by the family court to pay maintenance. His lawyers argued that the application should have been against his guardian since he was a minor. The High Court, however, rejected that. Justice Madan Pal Singh held that Section 125 of the CRPC, which deals with maintenance, simply says any person with means. It makes no exception for minors.
But how can a minor have the means to pay in the first place?
The court did acknowledge that a minor may not realistically be able to support a family. But since the husband turned 18 during the course of this case, the obligation to pay maintenance kicked in. But the High Court ultimately reduced the total maintenance from Rs 9,000 to Rs 4,500 per month, treating it as 25% of an assumed income.
And one more quick check, the CCI's probe into PVR Inox. This is about the virtual print fee or VPF, which producers say has stuck around long after cinemas went digital.
Exactly. The Producers Guild complained that this VPF, as high as 27,500 per film, per screen, hits small independent filmmakers hardest. The CCI noted that PVR Inox controls the largest share of multiplex screens in revenue. Continuing to charge this fee without offering a new service could violate Section 4 of the Competition Act for abuse of dominance. The CCI has ordered a full investigation within 90 days. If the findings are against PVR Inox, they could face penalties or be forced to refund producers.
And finally, the Delhi High Court pulling up the center on the Transgender Protection Act.
The court was really unhappy that replies to petitions pending since 2017 and 2019 haven't been filed. Petitioners are being denied benefits and corrections to official documents. The law is clear. A transgender person with an identity certificate is entitled to update their name, gender, or photograph on all official documents. The court was firm, saying that government can't just stay silent in such sensitive cases, giving them 4 weeks to reply and stressing that the National Council under Section 16 of the Act must start functioning. The takeaway is that these protections, though guaranteed on paper, become hollow if the state drags its feet.
That was a fantastic roundup, Ostika. And as always, the law is busy shaping our world. Thank you for breaking it all down.
Always a pleasure, Debojit.
This was Court This Week by LiveLaw. This is Advocate Ostika Das. I'm Debojit. Thank you for watching.